I'm Barbara Norman. I'm the Chair of Urban and Regional Planning at the University of Canberra and Director of Canberra Urban and Regional Futures, and tonight is part of our seminar series for 2016. And firstly, thank you for coming out on this quite chilly evening, so it shows a real commitment, and secondly for supporting our series, because I know there's some very familiar faces that have been coming, and so we're really delighted with that. We have two speakers tonight, two excellent speakers who will be introduced properly shortly. But and also, just before I introduce our Chancellor, the way this evening will work is it's over an hour, so 20 minutes for one speaker, 20 minutes for the second speaker, and 20 minutes for questions and discussion, knowing that there's drinks and nibbles afterwards, and that conversation can flow on after that, and I'm sure it will if it's like any other evening. The topic tonight is one that I think is long overdue, and I won't say many words, but I've been in planning for far too long, really, and it's an issue that, and very important consideration that I think has been lacked attention, sufficient attention in this country, I might say particularly in the south. So I'm really delighted that we are having this, and I hope it's the beginning of many more conversations around Indigenous land rights, Indigenous interest in land planning and environment and urban planning in cities as well. But before we introduce our speakers, I'd like to introduce our Chancellor, Professor Tom Calma, who is a very distinguished person in his own right. And if I went through all the 3 CVs tonight, we'd have the entire seminar taken up because they're amazing. So I feel really privileged to have you all here tonight. Professor Tom Calma will do the welcome to country and introduce our speakers. So thank you very much for being here.
Well, thank you, Professor Norman, and welcome to the University of Canberra. I won't be doing a welcome to country, but I will be doing an acknowledgement that we're in the land of the Ngunnawal peoples, but we also recognise that we've got the Ngambri people and the Wallagaloo people in this region who all work with us. It's a great pleasure to be here and to say a few words, and on a topic that's I think very important, and we've got 2 great speakers with us tonight, and I think it's a topic as that says up there, or the coexistence of recognising and respecting Indigenous rights to planning. When we consider that in Australia, at the moment, almost 40% of the Aboriginal land mass is either owned or controlled in one way or another by Aboriginal and Torres Strait Islander people. The majority of it's pretty arid, and it's a lot of desert country, but there's a significant amount of country out there. And so when we start to look at these big issues around planning, they become complex, and also to date we haven't had much effort put into really respecting Aboriginal and Torres Strait Islanders' existence on this land prior to the time that Cook first set foot on the land in 1770. I guess the other complexing issue is that across the nation there's a whole lot of different land legislations that exist, from native title, which we hear a lot about, to the Aboriginal Land Rights Act in the Northern Territory, which is a Commonwealth Act that flows into the Jervis Bay and also South Australia, to each of the states and territories having a form of land rights. And in all of that, other than maybe naming a few streets and a few places, we don't enough recognise the existence of Aboriginal and Torres Strait Islander people. And as I think Ed had cast the term, it's a wicked problem that we have to really look at. And I think it's definitely a wicked problem that challenges all of us. And we have to do it in a way that's both culturally safe and culturally acceptable to Aboriginal and Torres Strait Islander people. And so, it's got to be much more tangible than just naming streets, but it's recognising place. And for us at the university, it's a real big challenge, because even though the land is not designated as Aboriginal owned land, all of our campus developments are going to be on land that is originally owned by Aboriginal and Torres Strait Islander, or Aboriginal people in our case down here. And so we are, in fact, part of our thinking is making sure that we do recognise that pre-existence here. But I won't take up much time, more than this, but I wanted to acknowledge our two speakers. The first is Professor Mick Dodson, and Mick and I go back a long way, but he's the director of the National Centre for Indigenous Studies at ANU, and he's also a professor of law at ANU, the College of Law at ANU. He's worked as a legal counsel to the Royal Commission on Aboriginal Deaths in Custody, and worked internationally with treaty bodies, or at least the Indigenous bodies who work with treaties. So he's got a long history in that regard, but he's also worked at the community level, running community legal services and being actively involved in those areas. Excuse me. I do declare that I'm also an associate adjunct professor with Mick at the National Centre for Indigenous Studies, and also that, as the irony goes, I've followed Mick's career practically as well as literally. He was the first Aboriginal and Torres Strait Islander Social Justice Commissioner. I was the third. He was the co-chair of Reconciliation Australia. I'm now the co-chair, and also he was the former chair of the Australian Indigenous Leadership Centre, for which I was a chair, but I'm now just a member. And so we have this relationship, but both also growing up in Darwin in the early days. And our second speaker is Ed Wensing, and who's a PhD scholar over at the National Centre, and his topic of his doctoral research is on land justice for Indigenous Australians, 2 different timelines, 2 different cultures, and 2 different laws. Says it all. And it goes on to say, can 2 culturally different systems of land ownership and tenure coexist with each other? And hopefully Ed will tease a bit of that out tonight. But his background is that he's an experienced urban and regional planner and policy analyst with over 40 years' experience. Not that he looks that old, but he must have started young. He's worked extensively with Aboriginal and Torres Strait Islander peoples and communities in a range of disciplines, including land use planning, land administration and land tenure, native title rights and interest, heritage protection and management, and natural and cultural resource management. I think Mick is going to be our first speaker, so can we welcome Professor Mick Dodson.
Thank you, Tom. Good evening, everyone. I'd like to acknowledge the traditional owners, and I pay my respects to their elders past and present. I'm going to talk tonight about applying the UN Declaration on the Rights of Indigenous Peoples and the right to free, prior and informed consent when it comes to planning. Where do I start? Well, 1923. In 1923, a Haudenosaunee chief of the Iroquois Confederacy in the United States, Chief Descahay, travelled to Geneva to speak to the League of Nations and defend the right of his people to live under their own laws, on their own land, and under their own faith. Now, he wasn't allowed to speak at the League of Nations, and he returned home in 1924. But his vision nourished many who were to follow, although not immediately. A similar journey was made in 1924 by a Maori religious leader, T.W. Ratana. He went to protest about the breaking of the Waitangi Treaty, concluded with the Maori in New Zealand in 1840. that was meant to give Maori the ownership of their lands. He first travelled to London to complain to King George, but he was denied an audience. In 1925, he went over to Geneva and again was denied access. Now, nothing much happened internationally until the 1970s, when another Haudenosaunee chief, Chief Aaron Lyons, took a delegation to the United Nations in Geneva. And this time they did get noticed. The United Nations set up a study by Martinez Cobo, also known as the Cobo study. And he was looking into the problem of discrimination amongst Indigenous peoples around the world. The study, I think, still holds the record for the longest study in UN history. But it led to the establishment in 1982 of the Working Group on Indigenous Populations, the UN Working Group on Indigenous Populations. And from 1985, that group was tasked with the job of preparing a United Nations Declaration on the Rights of Indigenous Peoples. And in recent years, the declaration has emerged as a major focus of international debate around Indigenous issues. Now, Aboriginal and Torres Strait Islander people have been involved in this from the beginning of the 70s. And from an Australian perspective, international human rights standards have indeed evolved over the last 30 or so years, and more particularly since the decision on native title in the Mabo No. 2 case. And when we look at the United Nations, I think we need to understand that it's a house for nation states. And this is the foundation of statehood. Of course, it's given status in international law, which is not easily gained or granted, particularly for Indigenous peoples. But notwithstanding this, since World War II, Indigenous peoples worldwide have achieved extraordinary things within the international human rights system. And since World War II, human rights has arisen designed to moderate and regulate conduct of states towards their citizens. From the late 1940s to the present, a suite of human rights conventions, treaties, declarations and other instruments have emerged through the UN system and others. And if you examine the history of the evolution of human rights, it's been predominantly evolved because it's been very interested in the marginalisation of minorities and small groups of people. And Indigenous peoples of the world are the most marginalised. And I think this is part of the reason that we as Indigenous peoples have picked up on international human rights and utilised them and used them in our human rights law agitation and movement. And as I intimated earlier, Aboriginal and Torres Strait Islander peoples have used the international human rights system to tackle discrimination and abuse of our own rights. And since the 1970s, because of the Cobo study, the UN has increasingly become a place for Indigenous people from around the world to voice their concerns about their rights. And in the last 20 years, the international community has increasingly recognise the special attention that needs to be paid to the individual and collective rights of Indigenous peoples. Now, I raise this because Australia is part of the United Nations, and there are several, in the context of what we're discussing tonight, there are several international instruments that are directly relevant to Australia. Of course, the United Nations Charter, the Universal Declaration on Human Rights, the International Convention for Elimination of Racial Discrimination, all forms of racial discrimination, the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social and Cultural Rights, the ILO Convention number 169, the Convention on Biological Diversity, the Universal Declaration on Cultural Diversity, the Convention on the Protection and Promotion of Diversity of Cultural Expression, and of course, the Declaration of Rights of Indigenous Peoples. Two of those, the ILO Convention 169 and the Declaration on Indigenous Rights, are the only international instruments that are entirely dedicated to or focused on the rights of Indigenous peoples. ILO 169 is a treaty document, but the declaration is not. As a treaty document, it's legally binding on its signatory, and Australia is not a signatory to ILO 169. So let me turn to the Declaration of Rights of Indigenous Peoples and try and make it relevant to our discussion tonight. As I said, the origins can be traced back to Cobo's study and subsequently the request from the United Nations Subcommission on the Prevention of Discrimination and Protection of Minorities to the ECOSOC, the Economic and Social Council of the United Nations, that established the working group on the rights of Indigenous populations. Now, even though we as Indigenous peoples are meant to enjoy the same rights as all other peoples, the reality has been that we were being severely discriminated against throughout recent history. And Cobo found that it was through massive genocide, massive violence, outright massacres, ethnic cleansing, and what he called persuasive humiliation. And he documented that discrimination in the 1970s. And that really gave rise to the generation of the desire to develop a Declaration of the Rights of Indigenous People. Now, in May 2016, the UN Permanent Forum on Indigenous Issues called on the world to, the members of the UN more particularly, to adopt a human rights-based approach to development issues. And the millennium, they said that if the Millennium Development Goals were to be achieved, specific attention must be paid to the rights of Indigenous people. And in September 2007, this declaration was endorsed by the United Nations General Assembly. And I guess this is the most significant achievement by Indigenous people in the international level. Because under Article 3 it gives the Indigenous, it recognises the Indigenous people's right to self-determination. Under Article 10 it says that Indigenous peoples should not be forcibly removed from their lands or territories. Article 11 talks about Indigenous people having the right to practice and revitalise cultural traditions and customs. Article 19 says that Indigenous peoples have the right to be consulted in good faith in order for governments to obtain their free, prior and informed consent before adopting or implementing legislative or administrative measures that may affect them. Article 23 says that Indigenous peoples have the right to determine and develop priorities and strategies for exercising their right to development. Article 25 says that Indigenous people have a right to maintain and strengthen their distinctive relationship with their traditionally owned or otherwise occupied and used lands, territories, waters, coastal seas, and to uphold their responsibilities for future generations. Under Article 26, Indigenous people have the right to lands, territories and resources, and the right to own, use, develop and control the lands, territories and resources they possess by reason of their customary ownership. Under Article 27, states shall, it says, establish a fair, independent, impartial, open and transparent process giving due recognition to Indigenous peoples' laws, traditions and customs and land tenure systems to recognise and adjudicate the rights of Indigenous peoples pertaining to their lands, territories and resources, including those which were traditionally owned or otherwise occupied or used. That's an important point that Ed will take up. And finally, Article 32 says that Indigenous peoples have the right to determine and develop priorities and strategies for development or use of their lands and territories and other resources. Now, all of these rights can be seen, I guess, as enabling rights that are fundamental to the realisation of the full suite of development rights, including the right of cultural difference and the right to pursue a pathway to social and economic development that is determined, controlled by Indigenous peoples themselves. Now, these, how are we going for time? These 5 rights can be considered as a concession that's been made at international level for the loss of the opportunity for Indigenous people living in established states to claim statehood over territory. And without these, there's no real meaningful site for the aspirations towards cultural difference and economic development that are exclusively under the determination and control of Indigenous peoples. So what of the principle or the right to free, prior and informed consent? Well, the Australian Human Rights Commission has prepared a community guide to the United Nations Declaration on the Rights of Indigenous Peoples. And the guide contains some very sound advice. It says that when making policies, laws or undertaking activities that affect Indigenous peoples, governments and others should negotiate with those Indigenous people with the aim of obtaining our consent. And for governments, this is a much stronger requirement than merely providing information or consulting. Governments and companies as well should not be imposing their position on our peoples without first taking this right into consideration. This is why principles in the right to free, prior and informed consent were inserted in the Declaration of the Rights of Indigenous Peoples, and it's a golden thread that runs through the Declaration. So it entails, these principles entail free, It's got to be done without force, without bullying or pressure or undue influence. Prior, it means it has to be done before you do any development or any planning. Don't try and do this after you started. It's a bit late. Informed means that the affected Indigenous peoples are given all the information and be informed if that information changes or when there's new information. Because if our people don't understand this information, then we hardly have been properly informed. And in some instances, you might need to use an interpreter or another person might need to assist. Consent means that we must be consulted and participate in an honest and open process of negotiation that ensures that all parties are equal, neither having more power nor strength. Our group decision-making processes are allowed to operate, and our right to choose how we want to live, and that our worldviews are respected. And applying these principles will create a process whereby government, developers and our peoples can talk to each other on an equal footing and come to an agreement that all parties can accept. And this also means that Aboriginal and Torres Strait Islander peoples are to be involved in the design, the development, implementation, monitoring and evaluation of all programs, policies and legislation that affect us. That's what the Declaration says. And this includes planning documents and development assessment decisions made under planning statutes. The greater the impact, the greater the damage that a decision or project will have on our people's lives and our cultural integrity and our lands and territories, the greater the need to reach an outcome that we can agree to. If an action is a direct threat to our survival or cultural integrity, then we should be entitled to say no to that action. Now, all of the primary land use and environmental planning statutes around Australia require that planning instruments prepared under them be subject to some form of public consultation. Most of the planning statutes also require some form of notification, an opportunity to comment or consultation with affected parties when development applications are lodged for consideration. But all of the statutes are generally silent on how the public consultation is to be undertaken. This means that entities undertaking consultations under the Act are generally free to decide what form of any public consultation will take in relation to, for example, the preparation of local planning schemes or the assessment of development applications. This means that entities performing functions under planning statutes have the discretion to apply the principles of free, prior and informed consent when engaging with Aboriginal and Torres Strait Islander peoples and communities that may be affected by their actions. And the challenge, ladies and gentlemen, for planners is to take up this challenge, especially in areas where it clearly knows that Aboriginal and Torres Strait Islander people or our communities will be affected by the outcomes of any particular planning instrument and decision. And I can assure you that efforts to apply these principles in relation to land use and environmental planning activities will be warmly welcomed by our people. Thank you.
My first duty, as always, is to, of course, acknowledge the traditional owners on whose country we're meeting and to pay my respects to their elders past and present. And I also wish to pay my respects to Mick Dodson, who's currently supervising my PhD and chair of my supervisory panel, and to Tom Calmer, of course. And I also want to say thanks to Sophie McGlynn for the voluntary research assistance she gave me at very short notice, which was extremely welcome because I needed somebody for this presentation to go through all the planning statutes around Australia, so I knew what I was going to be saying. Just a quick word about terminology. I use the term Aboriginal and Torres Strait Islander rights to embrace a much broader definition than we would commonly use. I use it to embrace rights and interests, and by that I mean the kind of rights that are recognised in the international instruments that Mick talked about, and of course the rights that are now enshrined in our statutes through the Native Title Act, for example. I also talk about knowledges and values and worldviews. I think that Aboriginal and Torres Strait Islander people have a whole worldview of their own, which of course is not a singular one, but multiple, right across all the different groups and clans across the country. And I also want to embrace their needs and aspirations. Just quickly, one qualification I'd add to the rights is that we also need to recognise that under the native title system, the Native Title Act is very narrow about the kind of rights that will be recognised. We need, as planners, to acknowledge the fact that there are always going to be other Aboriginal and Torres Strait Islander people who may have connection to country that may never have amounted to a native title claim through historical, familial and other connections. So that's always something to bear in mind. As you saw on the title to this, I want to divide this presentation into three things: complicities, incongruities and prospects. And I think planning has lots of all of those, and I could spend all night giving you examples under each of these. But quickly, I want to cover the complicities very quickly because I want to dwell a bit more on the other two parts. Firstly, we have to realise that planning has a colonial legacy. When Governor Phillip arrived in 1788, he was supposed to bring the plans for Sydney with him, and Mick reminded me yesterday in conversation that actually Governor Phillip had left them behind. So he sent the surveyors to work. And as planners, our tools are cadastral systems, mapping, dividing land into counties, shires, parishes and hundreds is the old term we used to use. And we set about doing that. We paid absolutely no respects to the connections that Aboriginal and Torres Strait Islander people had with the land. Our definitions of boundaries were completely different to theirs, and we just completely ignored them. Dennis Byrne argues in a very well-written paper a few years ago that surveying and land selection were integral parts of the colonialist endeavour and the beginning of the dispossession and marginalisation, and they certainly were. And PIA can in fact take a really giant step forward. The Planning Institute of Australia can take a giant step forward by apologising, acknowledging that this is part of our history and apologising for it. Of course, the other part about the complicities is that we need to understand why planning actually matters. It matters to us because it impacts on our everyday lives. You know, as planners, we shape society. We are mediators. We are custodians of the public interest, whatever that might mean. And we're supposed to be ethical. And we do make a difference in the world, although sometimes not always for the better. But we have a really bad track record of acknowledging Indigenous interests in planning. And we have a long way to go to correct that. And I'm going to talk a little bit about that under the next two headings. In terms of the incongruities, I want to cover three things: the absence of statutory requirements in our planning statutes, the failure to recognise native title holders and claimants as owners in planning statutes, and the absence of Indigenous content in planning education. So firstly, let me deal with the absence of the statutory requirement. I went through the planning statutes in some detail, and the Commonwealth has no head of power for land use planning, so that's why they're absent. They're only here at the top of the table because there's a Commonwealth statute that sets the framework for planning in the ACT. What I've applied here on the far right column is the traffic light colour code. Red meaning no good, green meaning at least some content, and the others are meant to be either a light green or an orange, but they didn't quite work out like that on the screen. Very quickly, the ACT, the Northern Territory, Queensland in its current statute, there are two statutes there for Queensland. There's the Sustainable Planning Act, which is the current legislation in place, soon to be replaced by the Planning Act next year. And South Australia, similarly, there is the Development Act, which is the current statute, and the South Australian Parliament's also passed a new statute called the Planning and Development Infrastructure Act, which will come into effect next year. So all of the ones in red, there is absolutely no content on Aboriginal and Torres Strait Islander people at all, no content whatsoever. What we see in New South Wales is a small provision tucked down the back of the Act, which is to do with the fact that in one particular circumstance, to do with the provision of state infrastructure, it might be on Aboriginal land, and therefore you've got to go and talk to the Aboriginal Land Council in New South Wales. So there's no real acknowledgement. Victoria is the one that's made a slight change in the sense that they've developed an alternative native title settlement regime, which under the Traditional Owner Settlement Act. So there was a consequential amendment to the planning legislation to acknowledge the fact that traditional owners in Queensland substitute native title holders. I'll come to that in a minute. The reason why the Queensland statute is showing a bit of green, I'll come to in my next part of the presentation as well. But the message I want to get across to you here is that currently none of the planning statutes that are currently in force across the country provide any positive provisions for the protection or the recognition of Indigenous interests. The other thing I wanted to do was to look at the definition of owner in the statutes. Not all of the planning statutes contain the definition of owner. In Western Australia, for example, it's actually in the Land Administration Act. In one other jurisdiction, it's in the Local Government Act. But what this table shows is that when you look at the planning statutes around the country, there is a definition of owner, and owners play a very significant role in the planning system. Of course, it's all about protecting property rights, and I'll come to this in the third part of my presentation as well. But the point I want to make here is that the current definition of owner in the planning statutes do not acknowledge the fact that since the Mabo decision, native title holders, registered native title holders and registered claimants in fact hold a property right, and that's not reflected in the planning system. Again, the only one that's done that to any degree is Victoria because of the consequential amendment to the Planning Environment Act as a consequence of the Traditional Owner Settlement Act. So there are two really significant incongruities, and they cause some significant problems for Aboriginal and Torres Strait Islander people. The third one I want to draw your attention to is the absence of any real positive Indigenous content in planning education. This is an issue that I've been quite vocal about for almost 20 years. I was the National Policy Director for the Planning Institute in 1996. Before the Week decision was handed down, I was asked to develop a policy on native title for the Institute. When I looked at the issue in more detail, I thought, and I did this in conjunction with the valuers, my advice back to National Council was I don't think we should go down the policy route. What we should be doing is providing guidance notes for our members on their obligations under the Native Title Act, particularly with respect to future acts. So we did that, but the Institute still wanted to go down what I regarded as a fairly racist route in its policy directions, so I resigned. I then got snapped up by the Australian Local Government Association to develop native title resource materials for them. But when I left the Institute, I wrote this paper here on the far left of the screen on your side with John Sheehan about what the implications are for planners and valuers. And in that, there is a chapter in there that outlines how I thought planning education should change as a consequence of the Mabo decision. Nothing happened. Then in 2007, the Institute formed an Indigenous planning working group. There was a group of about a dozen of us who were actively working with Aboriginal communities on planning matters across the country. It was a fairly informal network, but I gave them a copy of that 1998 paper and said we really should update this and press the Institute to start changing the accreditation criteria for the recognition of planning courses for qualification for membership. We produced this discussion paper in 2010, and at that point in time, the Institute was revising its education accreditation criteria. Well, that went down like a lead balloon. Nothing happened. Nothing changed in the accreditation criteria. Most of the members of the Indigenous Planning Working Group walked away from the Institute and didn't renew their membership. I think there are about 2 of us that are left, and I'm one of them. Earlier this year, the Institute has re-established that. Occasionally it does review its criteria. It's now going through that process again. So I gave them these 2 papers and said, ignore this at your peril. So I'll tell you about the outcomes of that shortly. So and there are about 30, or let me just say there are about 30 undergraduate courses around Australia, at 24 planning institutes of universities across Australia, and about 30 postgraduate courses as well. And while they don't, I can't say that none of them have any Indigenous content, many of them do, but none of them teach the practicalities and the technicalities of the interactions between the native title system and the planning system, other than James Cook University, where I teach part-time. And that's the only course in Australia that touches on that to a significant depth. And I do it in 3 jurisdictions. In that course, in the first semester, I cover Queensland, the Northern Territory and Western Australia, because my students at JCU come from across the Northern Australia. So let's look at prospects. Well, there is some hope for the future, and a lot of positive hope. Let me first look at the new Queensland planning legislation. The credit for this clause goes to Dr. Sharon Harwood from James Cook University. Last year we were engaged in a pretty deep conversation because the Queensland Government was about to review its planning legislation, and there was a public consultation process opened up. So Sharon wrote a couple of submissions to the Queensland Government, and we suggested that the planning legislation really should start on a positive note by acknowledging the fact that Aboriginal and Torres Strait Islander people have significant interests in Queensland and should be taken account of. Well, this is the end result. Luckily, the bureaucrats who were drafting the bill listened and inserted this clause, or these 2 clauses, into the Part 5 of the Act. Now, I haven't got time to read out clauses 3, 4 and 5 together, but the accumulation of these 3 clauses, these 3 provisions right at the front of the Act, they are tenure blind. They are tenure blind. This applies to every entity performing a function under the Act. So when the state government develops a state planning policy, when the state government develops a regional planning document that's a statutory document under the Planning Act, when local governments in Queensland prepare local planning schemes or local planning policies, they will be expected to show how they have advanced the purpose of the Act, and one of which is to value, protect and promote Aboriginal and Torres Strait Islander knowledge, culture and tradition. So the Queensland Government is to be commended for this, for having the courage to insert this into planning legislation. This is a first in Australian planning history law in Australia. This is a first. So this is a very significant development. And at this point, the new Act doesn't come into force for 12 months because it's a very significant overhaul of the Queensland planning system. So I've given them a bit of advice about this to say you need to roll this out very carefully and take time. It does raise, in fact, 6 really important questions. And let me just expand on the questions. Well, why has the provision of valuing, protecting and promoting Aboriginal and Torres Strait Islander knowledge, culture and tradition been included in the Act? Well, of course, the simple answer is that the government had the courage to do it, and the Queensland Parliament agreed. By the way, I listened to the debate in the Queensland Parliament live while this was going through. This particular clause was not objected to by the opposition as it goes through the committee stage. But the more complex answer to that is the answer that Mick's given you. That is, there's a whole lot of international law and national law now in place that's demanding that we take more notice of Indigenous people's rights. And that's why that provision's there. There's also another reason for that. And in Queensland, they have what's called the Legislative Standards Act. And one of the provisions in the Legislative Standards Act is a set of principles which says that you must pay respect to Aboriginal culture and island custom or something. I can't remember the exact phrasing. And this was the clause that Sharon put in her submission to the Queensland Government, which I think prompted them to go that extra step. Now, I'm not going to go through the other questions because the answers to those questions can only be answered by the people who hold that knowledge. It's not for the state to decide the answers to any of those questions. And I've told the state that. I've said you can't answer those questions. These are the 6 critical questions that have to be answered in implementing that provision. But you can't answer the last 5 of those. You can only answer the first one. So you do have to be really careful about how you roll this out across local government and across other state entities and across your own department in Queensland. So that's a critical development, and I think it's a very positive one, and I think it's one that the other states should try and emulate. In terms of coming to the definition of owner, well, there's a really good reason for this. As Mick said, the planning statutes have a lot of provisions about the need for consultation, But there are also lots of other rights that owners enjoy, or entitlements that owners have under planning statutes. And again, it's each of the major planning statutes across the jurisdiction. The colour coding is the traffic light code. Red means no, green means yes, and the colour comes up orange on the screen, but it's meant to be light green or something, or I couldn't decipher it. Tasmania, well, what can we say about Tasmania? You can't access the statute easily on the web. You can't download it as a Word document or a PDF, and it's almost impossible in RTF to search it. So Tasmania gets a really low score. Of course, the Commonwealth Act that applies to the ACT doesn't necessarily apply to individual landowners, so that's why there's a bulk of red. But you can see across this table that a landowner is entitled to a lot more procedural rights under planning legislation than native title holders might get under the Native Title Act. Now, when you go back to that earlier table, and I showed you the absence of reference to native title holders, because the High Court has emphatically said and continues to say in High Court judgments on native title matters that native title is a property right, there's every reason why the definition of owner in planning statute should be altered to refer to registered native title holders and registered claimants, because it would open up these processes for native title holders and claimants. Now, let me give you a case study why. Now, I'm not suggesting that any of the parties involved did anything unlawful or improper, but on the 15th of June this year, Mareeba Shire approved a tourism development on freehold land in a former mining township and on a pastoral lease just south of the township. And I think the next couple of slides will give you a bit of an idea. The township is here. The pastoral lease, well, the pink block is block 20, I think, on HG 725 or something. So the township boundary is the square, as you can see, and the homestead development is where the bulk of the development is going to be, around the existing Mount Mulligan pastoral lease. Now, when you look at the subdivision in town, what's missing from this block? What's missing from this map? When you see yellow being leased land, green being reserve, and blue being freehold, and that's the subject of the development. What's the other layer that's missing? The native title rights. You know, in 2012, the federal court decided that the Jungan people hold non-exclusive possession native title rights over this area. So when you look at the next couple of maps, again, press the water button. This is the township here, so this is the full township, but the pastoral, this is part of the pastoral list, which is non-exclusive possession native title rights. And yet the development application went through council, and in town, the yellow signifies the development, but the blue shows and perhaps the next one, I haven't put the slide up in here, but the blue shows where the non-exclusive possession native title is. Well, an owner, under the Sustainable Planning Act, under the Sustainable Planning Act in Queensland, an owner, if you're an adjoining owner to a development, should have been notified about this application. The reality is, this process, this DA went the whole way through council with absolutely no contact with the native title holders at all. No contact. They weren't notified. On the 24th of June, they happened to be visiting the pastoral lease and they saw the notice on the gate advertising the development. So when they went to the Shire to make inquiries about it, they were told that it had already been approved. So now you can see that they just don't get any entitlements. So inadvertently, there was no notification and no consultation with the native title holders whatsoever. So how did this happen? And why were the native title holders overlooked? Well, planning is culturally blind. You know, if the definition of owner had been changed in the Sustainable Planning Act to include registered native title holders or registered claimants, then they wouldn't have been overlooked. In fact, the pastoral lessee would not have been able to lodge the DA without the native title holder's approval in the first place. And in the case of the blocks in town, they would have been notified once the DA was lodged because they were adjoining owners. So if governments decline to change the definition of owner in their planning statutes, well, we have to ask the question, well, why would you not do it? And would that be racially discriminatory? Let me just quickly come to reforming planning education. Yes, there's been a new draft policy put out for consultation. I certainly wasn't happy with it, and neither was Libby Porter. And also, most of the universities in Queensland and Victoria also revolted against the process because they were going to go through the completion of this draft policy without further change. So we put in a fairly lengthy submission, and we managed to get a concession from the Education Committee to put a proposal to the PIA board about intergenerational change. The problem with the planning profession is that there are not many practitioners, not many, and certainly not in the academic sector, who know how to teach this stuff. So if we're saying that we have to have Indigenous content in our planning education, then we certainly need to start thinking about how we bring our profession up to speed, and certainly in academia. I really think that Tom Trevorrow, I think, really neatly sums this up. This quote is cited right at the very beginning of the Murray-Darling Basin Plan and came out of the consultations that the MDBA did in the preparation of the plan. So our traditional management plan was, don't be greedy, don't take more than you need, and respect everything around you. And that's the management plan. It's such a simple management plan, but so hard for people to carry out. Well, I think Aboriginal and Torres Strait Islander people have got a lot to teach us about land use planning, and I think it's time we started to take some notice. Thank you.
Thank you. It's been a fantastic discussion, and as I said, not before time, and I hope it's the beginning of many more conversations around this space at this university and more broadly. Now, it's my great pleasure to invite our Chancellor back to just do a final thank you. Thank you, Tom.
Thank you, Barbara. And time just flew, and I think we can really appreciate both speakers and their contribution to what we gave. Even though the bias was very much on native title and planning, as I mentioned earlier, we have all these different land legislations across the nation, and as was just mentioned about the Heritage Act, which is both federal and the state and territory ones that are really under challenge. In the Northern Territory, you know, the government is looking at reviewing the Aboriginal Land Rights Act, Northern Territory, and the Sacred Sites Protection Authority Act, all to look at ways in which they can go about redeveloping Northern Australia and to bypass some of the controls that Aboriginal people do have over land under the Aboriginal Land Rights Act. But it is a fantastic topic. It's something we could really explore a lot more. In fact, at the university we have the Collaborative Indigenous Research Initiative, CIRI, anyhow, I think that's what it stands for, UC CIRI, and we're looking at a couple of projects that we've funded, looking at land use and picking up on some of those dreaming tracks in New South Wales and how they move up here, and starting to record those in a meaningful way. So maybe at a future time, this is something that CURF might want to you know, get some feedback on those projects particularly, and maybe explore a little bit more of what we've talked about here, and put a bit of pressure on us to do a bit more on the university campus itself. But look, it gives me great pleasure to thank both Mick and Ed for great presentations, and they've opened up a lot more thinking than they've answered questions. But thank you both. Thank you.